My name is Jeffrey Norris, and today we're going to be looking at excessive force. In particular, I want to look at how excessive force liabilities have come to affect policy creation in police agencies and sheriff's departments around the U.S. It's no myth that police officers and law enforcement professionals encounter many opportunities to use force, and this can be used in many different situations ranging from violent citizen encounters to routine felony arrests. It's very common for us to see this in American society. It's portrayed in media outlets, it's portrayed in movies, it's portrayed on television shows, but regardless of the prevalence of this use of force, it's seen as a very controversial power that is given to law enforcement officers. Society does not like to think of force potentially being used against it, and excessive force has become a very significant area of liability, as many plaintiffs often claim that excessive force is used against them, resulting in them losing their constitutional rights. And this leads agencies to change policies so that they can avoid negative liabilities and lawsuits. So to better understand excessive force liabilities, I want to briefly look at what excessive force really is and the case law governing it. I am then going to analyze the Jacksonville Sheriff's Office and how they have modified their policies in order to avoid claims of excessive force. Now, I do want to note that when we get to the policy creation part of the presentation, we're going to be looking at policies for field operations, because correctional and post-arrest activities are often governed by case law that is different from what will be examined in this presentation. So what is excessive force? It's a term that's thrown around a lot today. We hear it a lot on the news. It's talked about a lot in our classes, but what is it? Excessive force is the use of force or violence of a degree that is more than justified to effectuate an authorized or legal police action. It's important to note that police use of force includes many actions, and this can range from serious actions such as using physical force to overcome resistance from someone an officer is trying to arrest, or it can be a simple verbal command an officer gives to a citizen. And due to the wide range of police force, claims of excessive force can come from many different situations. And these can range from major grievances, such as an officer beating a compliant individual they are attempting to arrest, to minor grievances, such as an officer making inappropriate verbal threats to citizens. Regardless of the severity of the use of force, excessive force is a pressing issue. In a study conducted from 2002 to 2008, 78% of citizens that experienced police use of force believed that it was excessive, and 15% of these individuals filed a complaint or lawsuit. So before we go on to look at how the Jacksonville Sheriff's Department has modified their policies to avoid these lawsuits, we're going to look at the case law governing excessive force, because this case law has really come to really structure the policies of police agencies. So the first case we're going to look at is Tennessee v. Garner, and this is a U.S. Supreme Court case, and the decision in it really came to govern claims of excessive force that arise from deadly force scenarios. And the case involves Memphis police officers that were called to the scene of a burglary. And when they arrived on the scene, they noticed a 15-year-old suspect fleeing the scene. As the suspect was fleeing, he began to climb a fence, and an officer shot him. And now most people would say, why did the officer shoot him? The suspect was just running away. He wasn't armed. He wasn't posing a threat. But the Tennessee officer was actually acting under state law. He was acting under a Tennessee statute that allowed him to shoot suspects to prevent them from escaping. Now, unfortunately, in this case, the shooting led to the death of the teenage boy. And this led his father to file a Section 1983 lawsuit alleging that his son's constitutional rights were violated by the excessive use of force. At the same time, he petitioned the Supreme Court to analyze the fleeing felon deadly force rule that contributed to his son's death. And as the SCOTUS examined this case, they came to hold that the fleeing felon rule, as it was applied in this case, is unconstitutional. They noted that you can use deadly force on a fleeing suspect, but there has to be specific circumstances and select situations where such a degree of force is warranted. In addition to this, the court decided that the use of deadly force is a seizure under the Fourth Amendment. The Fourth Amendment deals with more than objects and places, it deals with people. The use of deadly force is subject to Fourth Amendment guidelines and must be reasonable under the Fourth Amendment. So due to this decision, Ross notes that deadly force can be reasonably used in select situations. For example, it can be used when an officer has probable cause to believe that an individual may cause death or serious injury to officers or citizens. It can be used when a suspect is fleeing and poses a significant imminent danger to the public or other officers. So like I said, deadly force can be used on a fleeing suspect, but in select situations. An officer has to perceive imminent danger. An officer can't say, I'm just going to shoot that person because they're running away, or I'm going to shoot him because 2 weeks down the road he might hurt someone. An officer has to say, I believe that if I don't shoot this person right now, someone's going to get hurt in this moment. Deadly force can also be used if a suspect commits a dangerous felony that involves violence or the threat of it. Deadly force can be used if an individual threatens an officer with a weapon, and it can also be used if an officer has probable cause to believe that a suspect has committed a crime in which he caused serious physical injury or threatened to do so. Now, in addition to these guidelines, the Supreme Court noted that police officers should warn suspects before using deadly force. When this action is practical, it might not always be practical. Officers might not always have the few seconds to warn an individual about deadly force, but when they do, they should give a warning. The court also held that deadly force liability cases are to be decided based on the officer's perspective of perceived danger. And this is a significant protection for officers. When a deadly force liability case comes before a court, the court can't say, we recognize that you perceived an imminent threat, but we believe you should have not perceived that, so your force was unreasonable. If an officer is acting under the structures of Tennessee v. Gardner, if they are perceiving significant imminent dangers, they can use deadly force. It will not be excessive. Courts cannot come along months down the road and use hindsight to rule that actions are unreasonable. The next case we're going to look at is Graham v. Connor, and as you can see, this has to do with objective reasonableness. And in this case, the Supreme Court essentially extended its decision in Garner to hold that the Fourth Amendment governs all uses of force against free citizens, or those at liberty. And this is just people that are not incarcerated, whose freedom has not been confined by incarceration. Force used against persons of this status must be objectively reasonable. And this is a significant decision because it gives courts a uniform standard by which they can examine claims of excessive force that are made by individuals at liberty. These claims may include excessive force being used in arrests, investigative stops, and other actions of police. Now, also in this case, the court recognized that police work inherently involves the use of force, and they held that objective reasonableness would be evaluated on a case-by-case basis. And what that means is that there are no bright line rules. A court can't say that in this instance, punching a person is always reasonable, and that in this instance, kicking a person is never reasonable. Force must be evaluated based on individual cases, and factors such as the severity of a crime, a suspect's threat to officer safety, a suspect's resistance, suspect compliance, and more will attribute to whether or not police use of force is objectively reasonable. Officers must understand this standard, as what is reasonable in one instance may not be reasonable in another. Officers must always be aware of their actions to ensure that they are acting with reasonableness. The court also noted that these cases will be evaluated based on the perspective of officers acting at the time the event occurred. So again, courts can't come along months down the road and say that even though you were acting with objective reasonableness at the time of the event, we think it was unreasonable because of hindsight analysis. No, cases must be evaluated based on the perspective of the officer. So after we look at this case law, it's important to look how a prominent department, like I said, it's going to be the Jacksonville Sheriff's Department. It's important to look at how they have modified their use of force policies to adhere to these guidelines and avoid excessive force liabilities. I chose the Jacksonville Sheriff's Department because they are one of the 100 largest police agencies in the U.S., which often leads them to create innovative policies that will better aid the large areas they serve and the deputies they employ. I also selected this department because they are located in Florida, and the smaller agencies around us, such as the Stewart Police Department, PSL Police Department, Fort Pierce Department, these smaller agencies often look to this larger Jacksonville agency to copy their policies and successes. So before I move on, as I mentioned, use of force policies can cover many areas. And because of this, I'm going to look at the more common aspects of this liability, particularly deadly force policies, non-deadly physical force and neck restraint guidelines, high-speed pursuit mandates, structures governing the use of police equipment, and conducted energy weapon policies. So the first area I'm going to look at is deadly force. And as we all know, deadly force is force that has the potential to kill an individual. Within policing, it often involves using a firearm, and officers that inappropriately use deadly force may be found liable for utilizing excessive force. It's also important to note that this form of liability is becoming extremely mainstream as media outlets have begun to cover an increased amount of stories relating to police shootings and violence. And due to this increased prominence, there is a large public eye on police agencies, which makes it very important that officers are adhering to the guidelines set forth in Garner, and that agencies have policies that avoid liabilities. The Jacksonville Sheriff's Department does a great job of implementing these positive policies, and we're about to look at them right now. So deadly force is only allowed when an officer reasonably believes that level of force is needed to prevent imminent death or great harm to himself or another individual. So right off the bat, we're seeing a mandate that seems to come right from Garner. You can't use deadly force whenever you want to. You have to use deadly force when there is an imminent perceived danger. Again, right from Garner, lethal force can be used on a fleeing felon, but in select situations. An individual has to have committed a violent felony in which great harm was inflicted or threatened. An officer has to reasonably believe that deadly force is needed to stop the escape of the suspect, and an officer has to reasonably believe that failing to implement such force will place other deputies or citizens in imminent danger of death or great bodily harm. So again, to avoid liabilities, the Jacksonville Sheriff's Office has greatly limited the use of deadly force. It can only be used when imminent danger is perceived and in select situations. The department's guidelines also contain several other lethal force provisions. For example, firearms can't be discharged at or from a moving vehicle unless it is used as a last resort to prevent imminent death, or it is used as a last resort to prevent the escape of a felon that poses a risk of imminent death or bodily harm to the officer or another person. So again, the Jacksonville Sheriff's Department is limiting potential liabilities by limiting the number of instances from which unreasonable behavior could arise. It's unreasonable to shoot a gun from a moving vehicle. That vehicle is going to change bullet velocity, it's going to change the trajectory of the bullet, it's going to increase the likelihood of a misfire. So the Jacksonville Sheriff's Department is limiting the number of cases that this unreasonable behavior could take place in by only allowing this behavior when it is absolutely necessary. Also, officers are never allowed to fire warning shots, and officers cannot needlessly place themselves or remain in a dangerous situation and use that as an excuse for the utilization of deadly force. So an officer can't enter a deadly situation, escalate it to a point where deadly force is needed, and then stay in that situation, use deadly force, and say that the deadly force was justified. An officer could be found liable in that situation because they escalated it. Deadly force really was not reasonable, and the Jacksonville Sheriff's Department prevents liabilities in these cases by not allowing officers to escalate these situations and to remain in dangerous situations and then say deadly force is reasonable. Also, when firing a weapon, officers must use caution to ensure public safety. Officers can draw their weapons when they fear for their own or another's safety. That is a reasonable behavior. And when using a firearm, officers must follow the standards that they learn in the police academy and various firing range training sessions, as these standards often promote reasonableness. Also, coming right from the Garner decision, the department holds that deadly force must be analyzed by examining the reasonableness of the officer's actions based on the facts and circumstances surrounding an officer when they implemented the lethal force. So again, a hindsight analysis cannot come to find deadly force unreasonable or excessive. Additionally, the department states that officers should give a warning before using deadly force, except when such a warning is not practical. So it's very apparent that the Jacksonville Sheriff's Department has really followed the Garner decision in its deadly force guidelines. This can be seen through the fact that the department recommends warning an individual about potential deadly force before using it, through only allowing deadly force when an offender poses a risk of imminent death or bodily harm to an officer or another citizen, and through only allowing deadly force to be used on fleeing felons in select situations. Also, deadly force is to be evaluated based on the perspective of officers acting on the scene, not hindsight. And these mandates come directly from the Garner decision. It's apparent that the department is doing all they can to follow this decision in order to protect their citizens and also to deter liabilities. And realizing this prior point, realizing that the guidelines that the Jacksonville Sheriff's Department follows are essentially right from the Garner decision, really shows how much excessive force liabilities has impacted policy decisions. This department wants to avoid liabilities so much that their deadly force policies are essentially right from the Supreme Court decision, because they know that if they follow the standards set forth in this decision, they will be avoiding liabilities. So the next form of liability I want to look at that falls under excessive force liability is non-deadly physical force and neck restraints. So what is that considered? Well, non-deadly physical force is often used when an officer attempts to control an arrestee or an individual physically resisting police deputies. Such techniques often involve the use of takedown procedures, hand or leg strikes, and more. And, again, in American society, we see this quite a bit. We've all seen the cop show where the police are attempting to arrest someone and the person runs away and an officer tackles the person, two other officers jump on his back and they handcuff him and he's arrested. And it doesn't really seem that severe in these situations. But although it may not seem severe, many claims of excessive force liability come from this area because it is used very often in the field. So it's very important that police officers and sheriff deputies understand that they must act with the objective reasonableness set forth in Graham to avoid liabilities in these cases. Additionally, neck restraints are a specific type of non-deadly physical force that has garnered an increased amount of attention, and that's because they are extremely effective at subduing troublesome individuals. No one wants to feel like they're choking and can't breathe. The issue is that this strategy can result in death if it's improperly used. And when it's improperly used, it really opens up agencies to excessive force liabilities. So many departments have started to employ very strict standards mandating the use of this technique to ensure that officers follow the standards set forth in Graham and to ensure that their agencies are avoiding excessive force liabilities. So the Jacksonville Sheriff's Office, their non-deadly physical force policies really meet the standards set forth in Graham. To start with, this physical force can be used when it is absolutely needed to effectuate an arrest, to prevent a fleeing suspect from escaping arrest, and to protect officers or the public as long as the force is reasonable based on the immediate circumstances presented to an officer. And what I really want to look at is that term absolutely needed. The Jacksonville Sheriff's Department has restricted the use of non-deadly physical force to situations when it's absolutely needed. An officer can't say, this person's yelling at me, they don't really pose a threat to me, but I don't like them, so I'm going to use non-deadly physical force. No, they can only use that force when it's absolutely needed, to protect the public, to effectuate an arrest, to prevent a fleeing suspect. And by only allowing this force when it's absolutely needed, the Jacksonville Sheriff's Department is really promoting reasonableness, because if something is absolutely needed, it's most likely reasonable. The department also holds that officers using non-deadly physical force must follow training procedures, because these teach about reasonable force and advocate the reasonable use of force. The department also holds that officers must consider the totality of a situation, such as the severity of a committed crime, the degree to which an individual is resisting, and the imminent danger that an individual poses to others. This promotes reasonableness because an officer comes to objectively think about a situation as opposed to going off of their own feelings and subjective views. And an objective analysis of a situation leads to an increased chance of reasonable force and a decreased chance for liabilities. Also, due to the amount of liabilities and the potential issues that can come from the neck restraint techniques, the Jacksonville Sheriff's Office explicitly disallows the use of that strategy. So like I said, it's apparent that the Jacksonville Sheriff's Department really adheres to the standards set forth in Graham. If officers follow training guidelines and view situations based on the totality of the circumstances, as the Sheriff's Department dictates, deputies will be acting with objectively reasonable force. They will not be basing their force on subjective beliefs and feelings, but on proven methods and procedures. And if officers act on these proven methods and procedures, they will be acting reasonably and be avoiding liability. The civil liability of excessive force has resulted in the Jacksonville Sheriff's Office creating a policy that only allows non-deadly physical force when such techniques are reasonable. Because the department wants to avoid liabilities, they only allow non-deadly physical force when it's reasonable, and this helps them avoid negative lawsuits. Additionally, the large amount of liabilities that come from neck restraints, as I mentioned, has caused the department to outlaw this practice. And this prior point, the fact that this agency, because of the potential liabilities that can come from a specific strategy, because of that, this agency has outlawed that practice completely, really shows how much excessive force liabilities affect policy creation. Agencies really want to avoid liabilities, so they are really morphing policies to not only aid the public, but to prevent liabilities from coming against their agencies. So now we're going to go to high-speed pursuits. And the Supreme Court has actually held that when a suspect flees in a vehicle, they demonstrate a likelihood of dangerous and spontaneous conduct that may require reasonable force to be used against it. It's important to note that police pursuing an individual in a vehicle is force in itself. And when courts evaluate the reasonableness of these situations, they use the objective reasonableness standard set forth in the Graham decision. So it's important that police officers understand that the actions they take in police pursuits must be reasonable. If they're not, they can be subject to excessive force liabilities, not only from suspects, but also from citizens, because citizens are often very vulnerable during a police pursuit. So how does the Jacksonville Sheriff's Office avoid liabilities in these situations? Well, to start with, they only allow police to give pursuit when a fleeing suspect has committed a violent felony or is driving while intoxicated. So the department has really limited the number of situations from which unreasonable force could be used. You can only chase someone in these select situations, and I think everyone would say that it's reasonable to chase someone when a suspect is fleeing for a violent felony or when someone's driving while intoxicated, because they're putting other people's lives at risk. Also, even if this prior criteria is met, deputies and supervisors must consider factors like road conditions, weather patterns, and pursuit speed to ensure that an extremely dangerous chase will not ensue. So officers have to ask themselves, is it raining? Is it storming? Is it nighttime? Is it the middle of rush hour? Is there a lot of people on the roads? Am I going to be going 90 miles per hour down a 40 mile per hour road? Officers have to objectively view the situation to ensure that their actions will be reasonable and to ensure that public safety is adhered to. Also, a max of 3 officers may pursue one single suspect. If other deputies are involved in a chase, they are allowed to simply direct traffic away from the chase or throw down stop sticks. And lastly, the agency notes that public safety should take precedence over all other factors of a chase. So it's very apparent that the Jacksonville Sheriff's Department really wants their officers to act with the objective reasonableness set forth in Graham. The agency ensures that chases are reasonable by only allowing them in extreme cases. You can't go and pursue the guy that you clocked going 10 miles over the speed limit. It doesn't mean that he's going to get away. You can put his license plate in a program and mail him a ticket. But by limiting the number of situations from which unreasonable behaviors could arise, the Jacksonville Sheriff's Department really limits potential liabilities coming against it. Also, by requiring officers to consider conditions of the road, patterns of the weather, and public safety before giving chase, the department has created an atmosphere of objectively evaluating the reasonableness of a pursuit. And this really leads to officers engaging in tactics when it's absolutely necessary, as opposed to just blindly chasing after someone because they annoyed you about how fast they were driving, or they seem to disrespect you. Officers are engaging in activities when they are reasonable, and this avoids liabilities. Also, by only allowing 3 deputies to pursue a suspect, the agency protects itself from involving too many officers in a chase, which can lead to stressful situations and an increased likelihood for unreasonable behavior because officers just want to get the chase over with. Additionally, it's a proven scientific fact that when many individuals of one single group get together, they are more likely to engage in dangerous behaviors. So by limiting the number of officers that can be in a chase, the Sheriff's Department really limits the potential for this gang mentality that can lead to unreasonable behavior and potential liability. So we are now going to look at the Sheriff's Department policy on police equipment. So police departments have really attempted to minimize lethal force incidents by providing officers with equipment that negates the need for deadly force. And items that negate this need include batons, flashlights that can be utilized as baton impact weapons, which are often more specialized weapons, such as non-lethal ammunitions loaded into a gun, and chemical sprays. And although these instruments are very positive, although they negate the need for deadly force, the utilization of these items can still be unreasonable. So officers must adhere to the objective reasonableness set forth in Graham. So first we're going to look at policies on intermediate weapons. Officers can't strike an individual in the head, neck, or clavicle, as this can lead to death. The only time they can is if deadly force is objectively reasonable under the circumstances. It's unreasonable to let an officer strike someone in the head if that could kill a suspect when deadly force is not allowed. So the department right off the bat is limiting liabilities by not allowing potential deadly force to be used in non-deadly situations. Also, deputies can't strike someone with something other than an approved intermediate weapon, as this can bring claims of unreasonableness. You don't want an officer walking into someone's garage, picking up a baseball bat, and hitting someone when it's not really needed, and this can lead to unreasonable force and potential liabilities. Also, flashlights are not intended to replace batons, but they may be used as such if done reasonably. An officer has to follow the guidelines set forth for a baton and treat that flashlight as a baton to ensure that they are acting reasonably and avoiding liabilities. Also, whenever an officer uses or witnesses the use of an intermediate weapon, they must file a report, as this helps to keep officers accountable and ensures that reasonable force is used. Lastly, officers that carry knives are not to use them as weapons. These can escalate situations resulting in unreasonable force, and officers are not trained on the use of knives, so they may not be adequate in using them, which can lead to unreasonable behaviors and liabilities. As far as chemical sprays go, the Jacksonville Sheriff's Department has limited liabilities from the use of these sprays by limiting the number of situations in which they may be used. Deputies can use these sprays if they have the legal authority to take a person into custody, and if such a degree of force is reasonable under the circumstances presented to an officer. Officers can't use chemical sprays punitively or on restrained cooperative individuals, as this is unreasonable. This spray is used to subdue someone, not to punish someone, and the agency avoids liabilities coming from unreasonable behavior by clearly stating that you can't use this spray to punish someone. Additionally, when a suspect is exposed to the spray, they must be brought to fresh air, allowed to flush their body with water, and monitored to ensure that they are not responding negatively to it. And again, when the spray is used or the use of it is witnessed, reports must be filed to ensure reasonable behavior. Lastly, specialty impact weapons. This is a very aggressive form of force that can be used to bring order, subdue vicious animals, or control an individual when deadly force would also be allowed. Now, this form of force is very strictly mandated because it's essentially a substitute for deadly force. So this force, like I said, it can be used in place of deadly force to neutralize suspects posing an imminent threat of danger when other methods have failed, and when suspects have resisted with a minimum of physical resistance. So again, we see the Sheriff's Department limiting potential liabilities by limiting the number of instances that this force can be utilized. You can't just use it because someone yelled at you and you don't like them. You can't just use it because someone's making a lot of noise but you have them under control. You have to use it if you perceive an imminent threat of danger and if someone is resisting with at least physical resistance. Additionally, to ensure reasonableness, officers can only use this force if a tactical plan is governing its use. Force is much more likely to be reasonable, liabilities are much more likely to be avoided if there is a plan governing the use of an object. Also, like we saw with intermediate weapons, officers can't target the head or neck of a suspect unless deadly force is reasonable, because targeting the head or neck of someone can lead to death. Individuals must also be photographed and medically examined after experiencing such force to ensure their personal safety. Officers using this type of force or witnessing the use of it must file reports to ensure reasonable behavior. So it's very apparent that this sheriff's office had the Graham decision in mind when its policies on police equipment were created. The Jacksonville Sheriff's Department allows deputies to use their equipment based on the situations they encounter, as opposed to allowing hindsight to dictate the proper use of equipment. It's like we saw with the chemical spray. An officer can use that spray if they have the legal authority to take someone into custody, and if the situation is reasonable according to the officer's perspective, and that mandate comes right from Graham. Additionally, the department authorizes the use of this equipment when it is reasonable, and this can be seen through allowing chemical spray to be used only when an officer has the authority to take someone into custody, or only allowing the use of specialty impact weapons to neutralize significant immediate threats. So again, we're seeing liabilities being avoided and reasonableness adhered to by really structuring when items can be used. The department has also created numerous safeguards, such as not allowing officers to strike individuals in the head or requiring deputies to file reports to ensure that the amount of force used is objectively reasonable. It's quite clear that the potential for excessive force liabilities have clearly affected the Jacksonville Sheriff's Office. Their equipment guidelines very clearly adhere to the Graham decision. And this is because the department not only wants to help officers and the public, but they want to avoid potential liabilities. And adhering to the Graham decision helps them avoid those liabilities and negative lawsuits. So the last area we're going to look at is conducted energy weapons. And these are oftentimes tasers. And law enforcement agencies have really come to use conducted energy weapons on a very large-scale basis. And these are very positive weapons because they've come to reduce deadly force situations, and they really help officers de-escalate situations in a very controlled, efficient manner. But with that being said, officers may be found liable under the doctrine of excessive force if they do not use these weapons according to the objective reasonableness that has been set forth in Graham. So, the Jacksonville Sheriff's Office CW policies right off the bat adhere reasonableness by stating that officers must act according to federal and state laws. If you're acting according to a federal or state law, you're going to be acting reasonably, and you're going to be avoiding a liability. Additionally, when using CWs, officers must act along a continuum of force. That involves first drawing their weapon, then targeting an individual, and then firing a weapon. If suspects comply upon the drawing of a weapon or upon being targeted, officers are not to fire the CW. And this promotes reasonableness because, again, it limits the potential for unreasonable behavior. If an officer draws their weapon and a suspect immediately goes down to the ground and says, "I'm going to comply," the officer doesn't even have to use that CW. Questions of unreasonable force and potential liabilities don't even arise because officers didn't even have to use that type of force. Also, to ensure that the force is reasonable, officers must make sure that they drew their taser and not a firearm by accident. And a CW may only be utilized when an officer has the authority to take someone into custody, when the person is exhibiting physical resistance, and when the individual has the apparent ability to flee or harm officers or other individuals. So again, we're seeing this use of this force limited to specific situations, which advocates reasonableness and avoids potential liabilities. If the criteria mentioned on the last slide is met, officers may use CWs if the action is reasonable based on the circumstances presented to them. And to ensure that the weapon is used reasonably, just like officers are asked to do in the pursuit situations, officers must consider factors that will be applied in the use of their weapon. They have to consider how close will the weapon be fired from. They have to consider potential injuries that may occur. They have to consider if a suspect may fall and harm themselves. And they have to consider the amount of resistance that they, the officer, are experiencing. And all of this leads to objective analysis of situations. It takes officers from subjective feelings and leads to an objective analysis, which really advocates reasonable force and deterred liabilities. Additionally, to promote safety, the department does not allow CWs to be simultaneously deployed on one suspect, to be used on pregnant women, as this can cause complications with the baby, to be deployed near bodies of water, because if an individual falls in that body of water, they have no control over their body because of the electric shock going through them, and they could drown and die. It can't be used on someone operating a vehicle, as this could result in a very dangerous crash, and it can't be used on vital or sensitive areas such as the head. So by really promoting suspect safety, the department is also advocating reasonable behavior. Additionally, individuals subjected to CEWs must be assessed by medical personnel, and the use of a CEW must be reviewed to ensure that it was reasonably deployed. So it's quite clear that the Jacksonville Sheriff's Office CEW policies do a great job of adhering to the standards set in Graham. The agency ensures that the deployment of these weapons is reasonable by requiring officers to follow a continuum of force which works at de-escalating a situation. And officers are only allowed to use CEWs when individuals have resisted shows of force that exist on that continuum, and when certain conditions are met. So again, the Sheriff's Department is limiting the potential for this type of force to be used, which goes on to limit unreasonable behaviors and potential liabilities. And by advocating the use of this force in select situations, the Sheriff's Department is really noting the situations where this force is reasonable, which gives officers a good idea of when the force can be legally used and when it would lead to a liability. Lastly, the agency promotes careful thinking by requiring officers to verify that they did not accidentally pull out their firearm, by advising them to consider the totality of the situation, and by not allowing the use of CEWs in certain situations where there is the potential for great harm to be done to a suspect. So again, by advocating public safety, by advocating careful thinking of the weapon you're pulling out, by advocating objective analysis of situations, the department is advocating reasonableness, and they're really deterring potential liabilities. So it's quite clear that this department wants to avoid excessive force liabilities and to adhere to the standards set forth in Graham. So, in conclusion, when you really study the matter, it's apparent that police officers must use force to perform their duties. It's a part of their job. Unfortunately, this power can be misused, and it can result in the loss of constitutional rights and excessive force liabilities. Because of this, it's very important that agencies understand this form of liability and the case law governing it so that they can avoid potential lawsuits and adequately aid the communities they serve. The Jacksonville Sheriff's Office provides a great example of an agency that has created these beneficial policies that can help a department avoid liabilities while also serving the public that they aid. This department must be studied so that other agencies can better themselves and the communities they protect. And then this last slide is my references. This is what I've been citing all throughout the presentation. Whenever I did use a reference, it was always cited within the presentation, within parentheses. I thank you for your time, and I hope that you have a great day.